Car accident lawsuits do not take as long as most people think, but the insurance companies hope that you don't know this. In this video, I'm going to walk you through the actual step-by-step process of a Georgia car accident lawsuit. I'm going to include realistic timelines and what really happens at each stage. Hi, I'm attorney David Bronze. I started my career working for the insurance companies, and that meant my job was figuring out how to pay accident victims like you as little as possible. Seeing how that system works from the inside is exactly why I share these videos now. I want you to know the exact same tricks I used against people so that you can protect yourself. If you need to talk to an attorney you can trust, you can always give us a call here at Bronze Law at 678-616-8588. After handling thousands of car accident cases in Georgia, I've learned that the biggest barrier to fair compensation isn't the legal system, but the fear of the unknown. People imagine years of courtroom battles and massive legal bills, so they accept whatever the insurance companies throw at them for an offer. But here's what insurance companies don't want you to know. Filing a lawsuit can often speed up settlements rather than delaying them. Once the legal papers are filed, cases get assigned to more experienced adjusters with higher settlement authority, and negotiations that were stuck suddenly move forward and you start getting real offers. There is a specific moment when filing a lawsuit becomes necessary, and you will realize that based on your conversations and negotiations. But recognizing that moment can save you months of wasted time and potentially thousands of dollars. I want you to picture this scenario. 6 months have passed since your accident. The insurance company has offered $25,000 for injuries that are clearly worth $75,000, and they stopped returning your calls. They are going into the classic delay mode. You think filing a lawsuit means years of fighting in court, but in reality, filing that lawsuit signals that you're serious. It's going to get you assigned to a more experienced adjuster, and that often leads to fair settlement offers within a few months. You should file a lawsuit when 3 conditions exist. First, you've reached maximum medical improvement and you know your total damages. Second, the insurance company's offers are significantly below fair value. And third, negotiations have stalled for an extended period. At that point, you're just wasting time. Keep in mind, in Georgia, you have 2 years from the date of your accident to file a lawsuit. But waiting to that last minute can weaken your negotiating position and also put your attorney in a tough spot with the statute of limitations. So I want to give you a framework to make this decision. Here's your framework. If the insurance company isn't making meaningful progress toward their compensation within the first several months of negotiations, filing a lawsuit creates leverage. However, lawsuits do involve costs and risks. With contingency fee arrangements, you only pay attorneys like me the fees if you win, but you also pay case costs, and those are going to go up in a lawsuit. The actual filing process of starting a lawsuit starts with preparing and filing what's called a complaint. The complaint details your accident, injuries, and damages and lists all the allegations against the other driver. Your lawyer files this with the county clerk along with a filing fee, and then that lawsuit is going to be served on the defendant. When the defendant gets that paperwork, they have 30 days to file what's called an answer. After the defendant files their answer, there's usually a period of at least 6 months called discovery. Discovery is the evidence gathering phase, and it's often where insurance companies realize that they've been undervaluing your case significantly. I want you to consider this situation. You've been rear-ended, and the other driver claims you suddenly stopped for no reason. Well, during discovery, your lawyer requests their cell phone records and finds text messages that driver sent right before impact. They also depose a witness at the scene who saw the other driver on their phone. This evidence that was unknown to you before you filed the lawsuit can transform a disputed liability case into a clear-cut negligence claim, and that often leads the insurance company to do a 180 and substantially adjust their settlement offers. Discovery uses 3 main tools: request for productions of documents, or RPDs like we call them in Georgia. Those are where you can request documents in the possession, custody, or control of the other party, like phone reports, accident reports, vehicle repair bills. Then there's depositions. Depositions are where you get to ask the other party, or any witness, or anybody for that matter, under oath questions about the evidence in your case. And third, there are interrogatories. Interrogatories are a fancy word for questions. Each side in a civil case gets to ask the other side up to 50 written questions, and that other side has to answer them under oath. And that usually happens early on in discovery. During this discovery phase we're talking about, you're going to need to provide your medical records, employment documents, tax returns, and sometimes undergo an examination by a defendant's doctor called an IME, independent medical exam, even though it's anything but independent. You'll also need to restrict your social media activity because defense lawyers will search for photos or posts that contradict your injury claims. I have seen it time and time again. What you need to do during discovery is be organized. You need to get all your medical records together, put them in chronological order, gather all your employment records that show your lost wages so you can support your lost wage claim, and most importantly, document all your injuries and how they affect your daily living. You also want to prepare for your deposition by reviewing the accident facts and your medical care with your lawyer. You need to be honest about your injuries, but don't minimize their impact on your life. Your deposition is your sworn testimony, so preparation is critical. The court during this time period will also schedule what's called case management conferences. These are used to set deadlines and ensure that cases move forward in the litigation process and don't get stuck in litigation. During this phase, either side can file motions asking the judge to dismiss their case or rule in their favor without trial. These rarely succeed in car accident cases unless there are clear legal problems. After discovery comes a crucial phase that determines whether you'll ever see the inside of a courtroom. It's called mediation, and most judges order mediation in Georgia. Mediation resolves the majority of car accident lawsuits in Georgia, and understanding how it works can mean the difference between accepting an inadequate offer and achieving fair compensation. Here's how mediations work. Let's say you've been offered $50,000 for a case that you believe is worth $100,000. At mediation, a neutral, meaning a third party, someone besides your lawyer and the other lawyer, and it's usually either an attorney or retired judge, they're going to help both sides negotiate. You're going to start far apart, but through the mediator's guidance and pressure, they're going to slowly walk both sides toward the middle. So in my example, you might settle at $80,000, much better than the original offer and without the uncertainty of trial. You also need to know that mediation happens in a conference room, not a courtroom. A neutral mediator is literally going to shuffle between two rooms, carrying offers and arguments back and forth between both sides. That process is confidential, so both sides can speak freely without worrying their words will be used against them later. Most mediations last a full day and resolve cases. Many courts these days actually require mediation before trial, and some insurance policies require it as well. The cost of mediation is typically split between both sides, and while you're not required to settle, the pressure to resolve cases is significant. To maximize mediation results, you want to organize all your records showing your injuries, calculate lost wages precisely, and document how the accident changed your daily life. You also want to set realistic settlement ranges with your lawyer before you walk in. When you go into that mediation, you want to know what your lowest number is and be prepared to walk out when you hit that number. You need to be prepared to negotiate. Mediation rarely results in your initial demand, but it often produces settlements significantly higher than pre-mediation offers. If mediation fails, you face the one outcome that's going to create the most anxiety. But the reality includes both significant opportunities and serious risks. Only a small number of Georgia car accident cases actually go to trial, but when they do, the stakes become much higher, both the potential rewards and the risks of getting nothing. I want you to consider this reality. Say you've been offered $75,000, but your injuries are clearly worth $200,000. At trial, that jury of 12 strangers could award you $180,000, giving you substantially more after fees. But they could also award you nothing or a fraction of that amount if they don't believe your injuries are serious or they find you are partially at fault. Trial is high risk, high reward. Before trial, both sides have to exchange witness lists and evidence lists, documents they're going to present. Your lawyer is going to need medical experts to testify about your injuries and causation. We need experts to do it. You can't do it. They will also need accident reconstruction experts if fault is disputed, and economic experts to calculate lost future earnings for serious injuries. You have to keep in mind these experts I just listed can cost thousands of dollars each. The trial process starts with jury selection. That's where lawyers choose impartial jurors. Then we move into opening statements. That's where each side gets to present a preview of their case with the jury. Then each side gets to call their witnesses. That's where we present testimony, including medical experts, and documents and other evidence gets submitted into the case. Finally, there's a closing argument. That's where each side summarizes their case. On the plaintiff's side, that's also where you demand a certain amount be paid to you. And then the juries go out and deliberate before bringing back a verdict. Here's what you must understand about trial. Verdicts are unpredictable, right? You are relying on 12 strangers to decide the fate and value of your case. There is risk there. There's no way to sugarcoat it. Also, Georgia follows comparative negligence rules. So if that jury finds that you're partially at fault, your award is going to get reduced by that percentage. And if they find you 50% or more at fault, you get nothing. Your lawyer should be giving you an honest assessment of your case strength and likelihood of success based on similar cases. You need to understand and appreciate that trial preparation requires significant time and effort from you. Trials can last several days, and that's going to mean you miss work. You're also going to testify about your accident, injuries, and how they've affected your life. That's going to be intense. The defense is going to have medical experts that come in and challenge your injuries. They're going to minimize the severity of them or even try to blame them on things that happened outside the car accident. If you lose a trial, you might be responsible for certain court costs. That's number one. Number two, if you win, the defendant can also appeal. Though appeals focus on legal errors and not with the jury's decision, it's legal issues only. Appeals will take additional time and involve more costs. And appeals are challenging unless there were significant legal mistakes during trial. The entire lawsuit process we just talked about, from filing to resolution, is going to vary significantly depending on case complexity, court schedules, and whether cases settle or go to trial. Simple cases might resolve within a year, while complex cases with multiple defendants or serious injuries can unfortunately take several years. You also need to understand that insurance policy limits are crucial because you can't recover more than the defendant's insurance coverage unless they have significant personal assets. If the other driver only has minimum coverage, but your injuries exceed that amount, you're going to need to pursue underinsured motorist coverage from your own policy. And that's optional coverage you need to make sure you have. Before filing a lawsuit, you should consider the alternatives. Arbitration, though very rare in Georgia, it can be faster than trial, but it can also limit your recovery. There's also small claims court. Small claims court in Georgia is called magistrate court. There are pros and cons to it. And of course, you can also continue negotiations. That might work if you have new evidence or circumstances change. The key to everything we just went over is having realistic expectations, right? You've just heard lawsuits require time, money, and they take emotional energy. But they are often the only way to get fair compensation when insurance companies refuse to negotiate reasonably. As I told you, most cases do settle before trial, but you need to be prepared of the possibility of going all the way through trial to get fair compensation. If you've been in a car accident in Georgia and insurance companies aren't offering fair compensation, don't let the fear of the lawsuit process keep you from getting what you deserve. Call Braun's Law at 678-616-8588 for a free consultation. We're going to give you an honest assessment of your case, explain all aspects of the process, including the costs, timelines, and risks, and handle every step for you. And if you're wondering how to prove the other driver was at fault in your accident, I want you to watch this next video where I explain the specific evidence you need and the mistakes you can make that destroy your case, including insider tactics I learned from my insurance defense days.